to get started for the second half of the program. If I could please have everyone sit down. As interesting as your conversations are, I don't think they're going to be as interesting as the rest of the program. So if we could have your attention, please. Thank you. And I'll turn it back over to Seth.
Another question?
Yeah, here's another question. Let me take it.
All right, folks, are you ready for another hour and a few minutes, and then it'll time to go home. We spent a lot of time on the first case, but I must tell you that I thought the two speakers did a very fine job of illustrating a couple things. First of all, these were lawsuits in which there was a lot of emotional tension. And you had up here before you a couple really experienced lawyers taking their time, not expressing any emotion about it really, but telling you exactly what happened. And I thought the two of them did a brilliant job in that and establishing one other thing. That first Jackson 1 was settled. The settlement probably did both sides a great deal of good. And it illustrates one of the important principles that we all have to deal with as lawyers, and that is if the lawyers can trust each other and work together, it works out very much better for their clients. They come out with some sensible answers, they have less hassle, and it's one way to get things done. So particularly the younger lawyers, if the older lawyers don't know this, I don't know why they haven't learned it. It's the best way to practice law is to learn how to trust the people on the other side and have them trust you. Now we should turn to the criminal case. We do have a few questions which we will come to, but some of them also relate to the criminal case, so I thought we should have the criminal presentation now. And we will have the two primary participants beyond the most important participant, the judge whom you've already heard from, but we'll hear from again. So first of all, we'd like to have the prosecuting attorney, Mr. Zonen, next.
Carl, I met Billie Jean too. She called me as well. Actually, about 10 Billie Jeans called me during the course of the trial, all professing to be the mother of Michael Jackson's child. And I actually continue to get those phone calls. The most recent was about 6 months ago from an attorney in Louisiana who's representing a woman who is quite convinced that her child is Michael Jackson's child. And he now is rather eager to become involved in the resolution of Michael Jackson's estate. I told him it's not a terrible problem to resolve. We do have Mr. Jackson's DNA on file at the Department of Justice, and it's a question of a simple subpoena to be able to get the form that describes the DNA profile, and you can go ahead and have your client's child DNA'd. That is a verb nowadays. And that would resolve the issue, and I never heard another word from him. I was somewhat skeptical about the allegations all along. I had another lawyer who came to me and quite convinced during the course of the trial that his client gave birth as well to Michael Jackson's surrogate child, and that the child was taken away from the mother quite forcefully and inappropriately, and he was commencing lawsuit about that, and we should become involved in that investigation as well. We had those calls coming in on a fairly regular basis. We would get them often. They were detailed. Fortunately, we knew that a lot of the activity that Michael Jackson was involved in was, for the most part, involved in either his condominium in Los Angeles, his house on I think it was Havenhurst, or Neverland, and we had a pretty good understanding of the layout of those three locations. And to that extent, when people called and reported a variety of different incidents with Michael Jackson, the first thing we were able to do was ask where did it occur, and then we would say describe for us that particular location, and we could discredit fairly quickly those people who were making false claims, and there were many of them that came along during that time. We have a relatively short window of opportunity to be able to talk about some of the events that led up to the prosecution, and then I assume we'll have a few moments to talk about the trial as well. But to the extent that our office, the District Attorney's Office in Santa Barbara, became involved, let me just give you a little bit of background. And I'm going to talk to you a little bit about the young man today. I'm going to talk to you as well before I sit down about Gavin today, because it's interesting what his life has turned out to be now 6 years after the trial, and I think you would find that interesting as well. Gavin was one of, at that time, 3 siblings. He and his mother and father lived in a studio apartment in East Los Angeles, one room that had been neatly partitioned with bed sheets so that each or groups of them within the family, the 5 of them, had some measure of privacy. Gavin's father was an extraordinarily violent man who on a fairly regular basis and would administer violence not just upon his wife, Janet, the mother of these 3 children, but upon the children as well, mostly, though, reserved for his wife. They were married for over 15 years before the police finally came along and took the father out of the household. Gavin was 12 years old at the time, never saw his father again after that. When Gavin was about 10 years old, he was diagnosed with cancer, and it was a vile cancer. It was a cancer that had invaded his entire insides. There was a tumor that was about 10 pounds in dimension. This was a 10-year-old child, incidentally, so the tumor was about 1/10 of his body weight, or more. The cancer had spread into his lungs, and he was at death's door. At one point, doctors had had a conversation with his parents in the hospital. They thought that he was asleep, and they essentially said, to the extent that Gavin remembers that conversation, they essentially said, you should go ahead and start preparing for a funeral. He's not going to survive longer than another couple of weeks. Gavin did survive. It was over a year of very intensive adult-level radiation treatment, but he managed to beat the cancer, and today he's actually doing quite well. He's 20 years old. During that time, there were a number of different celebrities who were contacted by people who knew Gavin. They knew that he had been taking classes at the Laugh Factory on Sunset, Jamie Masada's operation. He was taking classes there on stand-up comedy, actually, taught by a number of different comedians, including one who's present in this audience today. After Gavin became very sick and was hospitalized and appeared to everybody he wasn't going to survive, a number of comedians were introduced to him, people who had actually worked with him as his mentor, that included George Lopez, it included Jay Leno, it included a few others, names that you know. People who he often watched on television because he was so sick and couldn't leave the clean room that he was in for over a year except to go to the hospital, that night and day was no longer of any relevance to him, and so he often watched the comedians on late-night television and really developed a fondness for a number of them. He also had a fondness for Michael Jackson, and when asked if there was anybody that he hasn't yet met, and again, he was at death's door, as somebody he would want to meet, who would that person be? And he said Michael Jackson. And somehow that arrangement was made. We don't really know exactly who the link was. We know a couple different people who've taken credit for it. We don't know if both of them were responsible or if it just happened. Michael Jackson at the time did reach out to people who were ill, particularly kids who were ill, and extend his largesse and his kindness to those people on a regular basis. He contacted Gavin, and the first conversation was many hours on the telephone, well into the late hours of the morning. Both Gavin and Michael Jackson at that time were quite nocturnal. They were up all night, Gavin because he couldn't leave a room, and night and day didn't have any relevance, and Michael Jackson because he was nocturnal. He liked being up during the nighttime and not outside during the day. Being in the direct sun was a particular problem given his skin condition that he had. But Gavin was invited up to Neverland, and Michael Jackson sent a limousine to pick him up, and his mother required that the 2 other siblings go with him if they were going to go, because they all went places together. And the first time, they went with the mother and with the father, and thereafter the mother didn't go back again for quite some period of time. Over the next year, Gavin actually survived his cancer. He got better. And today I believe he is completely cured of it. He has 1 kidney that was removed. He has a second kidney that functions at less than capacity. That hasn't stopped him. He's very active in sports, played high school football, has pursued a very normal life since that time. After he was healed, and there was a period of time where he was not going back to Neverland, he healed. He was going back to school, and he was functioning as a normal child, 12 years old. He was invited back to Neverland along with his siblings, his brother and his sister. His father was already out of the picture at this point. He was invited back to Neverland because Michael Jackson, who was not doing well at that time, either financially or career-wise, had not released any significant music at that time and was horribly in debt to the tunes of what we believe to be hundreds of millions of dollars, had invited in a documentary maker by the name of Martin Bashir to do a documentary. Martin Bashir had done a remarkable job. I have a bottle of water. Rod, if you would please hand that to me. Thank you. Which reminds me of another very quick story. Closing argument. We were required by Judge Melville to wear microphones when we were doing our closing argument. Closing argument was about 4 hours, and you go through a lot of this in a 4-hour period of time. If you go through enough water, what do? On the break, you immediately beeline for the restroom, which we had a personal restroom for the prosecution and the defense and all of our people in the same restroom. And, of course, I go in and I'm doing what comes naturally after you've consumed a number of these things and wondering at that split moment, did I turn off my microphone? And thinking what the headlines would read from the 1,500 reporters who were covering closing argument at that moment. Fortunately, I had turned it off at that time. Gavin was invited back to the ranch because while Martin Bashir was there and doing this documentary and covering Michael Jackson and everything that was Michael Jackson, including the trips to Las Vegas and the spending sprees and the travels to Germany and the baby over the balcony and all that was Michael Jackson, both good and bad, during that period of time. Martin Bashir was there at exactly the time that these children arrived at Neverland. They were brought back there because Michael Jackson was very proud of the kindness that he had extended to this family and this very horribly sick and impoverished family, but very sick child who had recovered, much to Michael Jackson's credit, as he puts it, that he had recovered from this horrible cancer. While he was there was a scene in this documentary that was filmed by Martin Bashir of Gavin sitting on a couch next to Michael Jackson with his hand in Michael Jackson's hand and his head resting on Michael Jackson's shoulder. And Michael Jackson is describing how these kids stay with him not just in his house, not just in his room, but in his bed. And that began a conversation with Martin Bashir, who's no idiot, who immediately decides there's something amiss here, and starts questioning him more about the propriety of children sharing his bed with him. And over the years, there were a number of them who were the special friends of Michael Jackson, all boys, all between the ages of 10 and no older than 13. By 13, they were pretty much out of the picture, but certainly, and generally not younger than 10 either. But this whole area was covered at length by Martin Bashir and ended up in the documentary. The documentary came out, and when it came out, it featured this entire conversation with Gavin and with Michael Jackson, sitting one next to another. Gavin juxtaposed next to Michael Jackson, his head on his shoulder, his hand in Michael Jackson's hand, talking about them sharing a bed for this prolonged period of time, of which Michael Jackson professed was a perfectly normal and perfectly innocent activity. Gavin went back to school, of course, within a few days after that and was horribly tormented by all the other kids who had been in the school and who had seen that. And, of course, the understanding of what that meant Gavin was something that would be pretty obvious to all of you, and that was exactly what he was confronted with by the other children. Immediately as this was happening, and even before that, the family was invited back to Neverland, and once back at Neverland, they stayed at Neverland in what was, we believed, an effort by Michael Jackson's handlers to keep this entire family away from the press. Why keep them away from the press? Because they wanted to be able to control the information that was coming out, and because the mother of the child, frankly, was uncontrollable. She was uncontrollable. She was somewhat, frankly, unstable. She was a person who could say or do anything at any particular time. She was a very difficult person for anybody to control. We dealt with significant issues with her during the course of the trial. And, of course, she was the principal feature for the defense, essentially, when the trial came along, that it was really nothing more than a shakedown, an effort to extort money. In fact, we, of course, were of the belief that no such thing happened. And as I describe a little bit more how these things unfolded, then you'll be able to make your own decisions one way or the other. While at Neverland for this period of time, this was the period of time that the boys ended up staying in Michael Jackson's house, in Michael Jackson's room for a long period of time. There was a trip to Florida right before. There was an effort by Michael Jackson's handlers to hold a press conference so that the kids could actually address the press and explain that nothing had happened during this period of time. and then back at Neverland for a period of a number of weeks while the mother was there, but in an entirely different guest cottage. The kids would be inside the house, inside his room, and to get into his room, you have to go through a locked door, then you have to go through a combination lock on the entryway to his private room, then you pass through the security system that sounds chimes and alarms as you go through, and then up the stairs to where the bedroom was. The kids had the combination to that lock. They came and went. By kids, I mean the two boys, not their sister. Sister lived in the guest quarters, and the mother lived in the guest quarters. The boys came and went inside of his room. During that period of time, there was an effort by Michael Jackson's handlers to move the whole family to Brazil. They actually withdrew the children from school. They moved the entire family out of their studio apartment in East L.A. They put all of their belongings into a storage facility where they actually didn't know where it was. Put all of their belongings into a storage facility. They got visas for them. They got passports for them. They got one-way tickets for them, all of which we had and all of which we put into evidence. And essentially they were going to move them to Brazil for an undisclosed or unknown period of time that simply could have been indefinite. The mother did not want to go to Brazil, and eventually she left Neverland. She brought her kids, got her kids out of Neverland, and she then contacted an attorney by the name of Dickerman. Why did she contact Dickerman? Because her possessions were someplace other than her. She didn't know where any of her possessions were, any of her property, her clothing, her furniture, to the extent that she had it. Again, she lived in a studio apartment. But she had no idea where any of her possessions were. She went to Dickerman, who was a friend of Jamie Masada. That was the recommendation. The second thing she wanted of Mr. Dickerman, the second thing that she wanted, was that her children should not be on television anymore in this documentary. There was never any permission that was given by her, and at this point she was the sole custodian of the children. Father was long removed from the scene. There were restraining orders that kept him from the family. Goes in to see Mr. Dickerman. She has no knowledge of anything inappropriate having happened at Neverland, other than the presence of the children in the documentary that she objected to. She goes to Dickerman. Dickerman sees these two young boys, and Dickerman has some knowledge about what happened in 1993, and he immediately contacts Larry Feldman. And they go to Larry Feldman. Dickerman has no personal information that anything inappropriate happened while they were at Neverland, but has some sense that maybe something more needs to be addressed on this. Dickerman knows what happened with Larry Feldman in 1993 in that particular lawsuit, and he brings the whole family to Larry Feldman. Larry Feldman looks at Gavin, who at this point is about 12 years old, almost 13, I believe, and sees in Gavin a very strong resemblance to the child from 1993. They're the same age. They're roughly the same size. They're roughly the same coloring. You could look at pictures of the two of them, along with two other children who had had this very, very close, intimate relationship with Michael Jackson years prior. You look at the photographs of all of them together, and at times it's hard to distinguish one photograph from the other. They all bear very much the same resemblance. Larry Feldman immediately brings in Stan Katz. Stan Katz is a psychologist who specializes in child sexual abuse. Stan Katz interviews both of the boys, and at that point there was a disclosure of child sexual abuse. It was to Stan Katz. Stan Katz immediately notified Child Protective Services in Los Angeles County, who notified Child Protective Services, and the Sheriff's Office in Santa Barbara County, and ergo, this investigation became active. At the time, the district attorney in Santa Barbara was Tom Snedden, who is now retired from that office, the position now held by Joyce Dudley. Tom Snedden was the district attorney at the time in 1993 and was involved in that investigation, had some insight and understanding of the entirety of the case that involved Larry's client back then. So he had a pretty good understanding of what was going on. Sheriff's Office commenced an investigation that ultimately led to a search of the property. At the search of the property, they discovered a number of things that were of interest to that prosecution, including a lot of the pornography that Michael Jackson kept in his residence, and particularly in his bedroom. It was all seized, and from that began the largest effort that Santa Barbara County has ever had in tracking down and identifying fingerprints on hundreds of magazines, each individual page, each revealing dozens and dozens of fingerprints. but many of those fingerprints ultimately confirmed to be fingerprints of Gavin and Gavin's brother. Material that they say was shown to them repeatedly by Michael Jackson in the house. As well, there was a vodka bottle. There was a number of different bottles of alcoholic beverages consistent with what the kids said had been served to them during the course of their time at Neverland, and particularly in Michael Jackson's residence. That was the search. The search eventually led to a grand jury hearing. Why a grand jury hearing? Who has participated in a grand jury hearing? Anybody here? We have a couple hands that have come up. We have a tradition in Santa Barbara. I can't speak to other counties, but we have a tradition for high-profile cases. And as you know, as bucolic and beautiful our little community of Santa Barbara, we don't go to Santa Barbara because we want to be high-profile lawyers. We go to Santa Barbara because we like to golf or sail, okay, or be on the beach. It is a beautiful, angelic little community. It's very nice, and none of us were necessarily accustomed to the kind of profile celebrity status that was going to be visited upon us in the course of that trial. All right. We made the decision to go to the grand jury because we felt it was appropriate, not just for that case, but all celebrity cases, all high-profile cases. It's just kind of an American tradition that the grand jury makes the decision. In this particular case, we also had the advantage of being able to do it in secret, hopefully keeping the transcript confidential and sealed, and such that everybody would be protected from the content of that hearing going public before we actually impaneled the jury. We felt it would be in Mr. Jackson's benefit. We felt it would be in our benefit, that it would be the right thing to be able to do. We also felt that if we could keep all of the press, and by now it was something I wasn't familiar with, the press with trucks everywhere as far as you could see, and we step out and they follow us. You know, just like in the television, you see with the camera following you as you're walking across the street on the way to court, firing questions, and of course at that point we had a gag order. We couldn't answer anything anyway, so there was nothing that we could say. But that was the type of environment we had. We looked for a place to hold the grand jury hearing where there wouldn't be anybody hanging around, and we did it at the Armory. We did it at the firing range for the sheriff's office, which happens to be on a number of hundreds of acres that are secluded from main roads. The jury would assemble each day at a different location in Santa Barbara in a parking lot that they were told the night before so that no press would be there. It was Albertson's parking lot. It was Sears' parking lot. It was something like that. Earl Warren's showgrounds up there. One of those locations, the van would then scoop up all of the grand jury. They would take them to the Armory, where we sat in a room which we had converted into a grand jury hearing. And for the next 3 weeks, we put on, I think, about 30 witnesses for the grand jury, including all three of the children and their mother as well, as problematic as that was and continued to be. We did get an indictment at that point. We made the decision to file it in Santa Maria because, as Judge Melville said, what happens north of the mountains stays north of the mountains. And we felt that that would be an appropriate forum. These events took place in Santa Ynez. That is part of North County officially. Any other crime that occurs in Santa Ynez would be prosecuted in Santa Maria, and that's where it was. Our expectation as well was that it would have been assigned to the then most senior judge in Santa Maria, and that would have been Judge Melville, and that was our preference as well. And that was how that ended up happening. To deal with the trial itself, because at this point, as we're getting close to the start of trial, we had accumulated something close to 100,000 pages of discovery. Now, Mesereau's going to yell and scream and convince. He only got 50,000 of those, but he actually got the whole thing. It was all turned over in the course of the trial, and it filled the house. And so we, the three lawyers from our office who were going to be trying the case, we all lived in Santa Barbara and decided that we needed to rent a place up in Santa Maria. And so we rented a house up in Orchid. Orchid's a very small, little nice, very nice bedroom community to Santa Maria, 8 miles south of the courthouse. And I believe that's actually where Judge Melville lives, is in Orchid. And a lot of the attorneys from our office who work there live there as well. We rented a house. The children, one of the children of one of the attorneys working on the case, ended up nicknaming the house the Hop, House of Prosecution. And that's where we went. And the schedule that we were on, 8 in the morning until 2 in the afternoon, actually worked quite well for us because it gave us from 2:30 until we finally would retire at the end of the day to be able to deal with everything. It was our offices. It's where we stored all of the material, all of the reports. It's where we set up the computer system. We had no way of being able to bring in all of the reports of the case into the trial after the trial had started. We essentially would put together notebooks every night for the next day as to which witnesses would be on the stand, or once the defense case began, who we would be cross-examining. I thought our relationship with the defense was fairly good. I mean, there was certain moments of contentiousness, as you can imagine, but we were very good about keeping them informed as to who we were going to be calling and when, and they were very good about keeping us informed as to who they were going to be calling and when as well. And that's how we were able to make it through the trial, ultimately. I think we're going to have more of a discussion about jury selection a little bit more. So I think we'll probably be going more into the aspects of the trial at a later time. But just in terms of the issue of the publicity, we did get a request in to the court for a gag order. That request was granted for the gag order. Yes, it was true that Tom Stedden held a press conference. I watched that press conference with many other people. At the time I was around the world. I watched it from the King David Hotel in Jerusalem, where I happened to be, and I was sitting there and thinking as it was happening, okay, my life is going to change dramatically at this point. I knew about it but hadn't told anybody, including all of my family. We had kept it as much of a secret as we possibly could. After that had happened, as Judge Melville points out, Mark Garagos was on Larry King many times a week, and continuously talking about the family of grifters that were plaguing his client for an obvious shakedown, and the revenge factor by Tom Stedden, given the fact that he was not able to prosecute Michael Jackson in 1993. Now, let me comment on two things at the moment as I conclude, because I told you I was going to talk to you a little bit about Gavin today. This was a child who grew up in one room. I mean, the first 10 years of his life were spent in one room with five other family members. He was the victim of a horribly abusive father and a witness to horribly abusive domestic violence. He was a victim of cancer that almost killed him. Before he was 12 years old, he endured all of that, and then watching his father being taken away. He was a rather extraordinary kid. Then met Michael Jackson, we believe molested by Michael Jackson, and subjected to a horrible ordeal of a trial. At age 15, he stood on the witness stand, took an oath, and sat down and answered questions for hours. Among the questions, of course, were detailed questions of sexual activity by an international superstar. Right. We lost the case. He was found not guilty, and we had to explain that to Gavin and what that meant, and what that would likely mean to his life from this point on, and how he would go about it. They moved to another location. He used a different name. He finished high school. He was outed while he was in high school. One of Michael Jackson's fans discovered where he was and fixed the computer in such a way that all of the MySpace for students at that school would immediately go directly to his new website, this person, which identified Gavin by his photograph as the person involved in the most uncomplimentary ways possible. Where is he today? He's 20 years old. He's a third-year student at a very prominent university on the East Coast. I'm not going to mention the name of the school, but anybody who would like to know, come see me, I'll tell you. He's an honor student. He has a 3.5 grade point average and a double major in philosophy and history. He's planning on going to law school. Some of you will agree with that, some of you won't. His major is philosophy and history. He's a deeply religious young man in a relationship with a young woman that has been a relationship for about 2 years, the daughter of a minister. He attends church on a regular basis. He doesn't drink. He doesn't use drugs. He's very intellectually suited. He's delightful in his presentation. I spent time with him only a month ago, and he's really doing remarkably well. He has never asked for or taken a penny from anybody about any of the activity of this case. Never. There are standing offers from the press for his story for enough money that it would cover his tuition, which is considerable. Never mind, he's on a 50% scholarship. But he has never taken a penny from anybody and has no intention of doing so. He's accruing debt like college kids do today, but he's doing just fine. I assume that we'll have more questions coming up about jury selection of the trial, and I'm happy to ask them at that time.
Thank you, Ron. We appreciate that, and I want to thank you very much for coming, because it isn't often that you get invited to come someplace to talk about a case that you didn't win. And if you talk about it, you don't talk about it very much. And so it was very helpful, very direct and straightforward, and we appreciate it. I think it was very good. Now, we'll hear one thing I should say. You undoubtedly know that our next speaker is really one of the most prominent criminal defense lawyers in the country and has dealt with so many of these cases. And I am just astounded, and I apologize, Tom, that you've been sitting here for an hour and a half, 2 hours now, and haven't had a chance to say a word. Now, that's a terrible thing to impose upon an effective lawyer. But we do appreciate your coming, and the podium is yours.
Well, first of all, I want to thank the Los Angeles County Bar Association for inviting me, and I think this is a great panel. Needless to say, I have a very different perspective on what you just heard. I don't believe for 1 second Michael Jackson molested any of these people. Neither did 12 jurors in Santa Maria, California. They acquitted him of 10 indicted felonies and 4 lesser-included misdemeanors. 14 in all. They couldn't get him on even a misdemeanor. He was innocent. Now, as far as the media is concerned, I know I don't have a lot of time, but I will tell you a few things about my approach to the media in this case. I was brought in eventually by Randy Jackson, who I'd known for years. And Randy called and wanted me to meet he and his brother. And he said to me, and he's a very smart guy, he said to me, we don't like what our lawyers are doing with the media. And we don't trust what's going on. In fact, he told me that during the first court appearance he was at, some lawyers ran out of the building and shoved him out of the way to get in front of a camera, which he didn't appreciate or like, and nor did he think it was in his brother's interest to have this kind of behavior. And one of the things he told me he liked about me and my partner, Susan Yu, was that he didn't think we were camera mad. He didn't think we were the kind of people that were going to basically put our own interests for fame or fortune in front of his brother's. And the first thing I learned as I met he and his brother was this: be very careful of the media. Be very careful of their desire to seduce. Be very careful of their desire to profit off the demise of the defendant. Be real careful. It became clear to me that we were never going to win a battle with the media. Now, I understand there's been some discussion that Mark Garagos was on TV, et cetera, but let me tell you something. The media worldwide were out to get Michael Jackson. The money was in a conviction, okay? I was told after the Barry Gordy, who founded Motown, told me after the acquittals that you cost the worldwide media billions by those not guilty verdicts, because the kind of copy that his being convicted, remanded to jail, the build-up to a sentencing, which would have been the biggest sentencing in world history, was something they wanted. You know, this was big, big business. They were doing everything they could to spin a conviction. And it became very clear to me you were never going to manipulate the media or win a case in the media, nor should you try to, because I think this idea that the media wins cases is grossly overrated. You know, the media said Robert Blake would be convicted, O.J. Simpson would be convicted, Michael Jackson would be convicted. If you get carried away with spinning the media, you can lose focus on where it really, really is most important, and that is in the courtroom, 13 people, the judge and the jury. I supported the gag order in the case. I dismissed Mr. Garagos' appeal of the gag order. I did that for a lot of reasons. First of all, in a big case, if you're dealing with the media, they can really sap your energy. I mean, and particularly if you have an entertainer client who is used to dealing with the media, who thinks trials are what you see on TV, as most people in the entertainment industry do. they can want you to respond to all these media attacks, and you could spend 24 hours a day doing that and detract from your ability to prepare for what's happening in the courtroom, which is where the cases are won or lost. So I supported the gag order. I did not want to have to respond to media requests. I didn't think we had time to. I didn't think it would be productive. And also, quite honestly, I didn't want Judge Melville to think I was there to be a pain in the neck. I mean, I was not new to the community. I'd never tried a case in that county. Obviously, he wanted that gag order. And my feeling was, why make the judge think, you're out to dramatize everything and make things a lot more difficult. So I supported the gag order. I thought the process that Judge Melville had an effect where if you wanted to make a statement because something prejudicial was out there, you submitted a statement to the other side and to him, and you had a quick discussion, which we would have. Judge Melville gave us his home phone. So we would have discussions about whether or not a statement should be made very quickly. He was always available to address that issue. And as he said, he never denied us. There was some haggling over language sometimes, but nothing major. I think it went very well. I think the unique procedure he had about filing motions and pleadings, that you could not file salacious pleadings. You would file the original pleading under seal. You would file a second pleading, which was a redacted version of the first one, which had to be prepared according to certain guidelines Judge Melville had, which were designed to keep the salacious stuff out. And you had to file a third pleading, which was a motion to seal. It was a very unique procedure. I thought it worked very well, and I do commend Judge Melville for a very, very amazingly effective way of handling this media onslaught. As I said before, I had never tried a case in that county, and we did a few phone surveys at the beginning through a jury consultant to try and determine just kind of what people were thinking and feeling. And again, we all do our job when we have to do it, but with all due respect, that settlement in the early 90s was an albatross around my neck, I discovered, because the typical profile of a pro-prosecution juror would indicate that the thing that bothered that profile juror the most was that settlement, the feeling being who pays this kind of money if they're innocent. When we profile the typical pro-defense juror, the thing that bothered them the most was the same thing. Why was all this money paid if you're innocent? I did issue a press release and made a public statement with Judge Melville's permission, of course, which attacked it. I had to do that. It was bothering too many people. And I basically said that Mr. Jackson had entered into that settlement because business advisors told him to. They weren't writing the check. They wanted to get him to get going in his business life and stop being derailed by this very salacious legal proceeding, and that he regretted doing it. It's something I just had to do because, in my opinion, it was killing us. Now, he had reasons for doing that. The $20 million, many people thought, was a drop in the bucket, given what he owned and what he had and what he could earn in the future. But nevertheless, it just bothered a lot of people. So I did have to address that issue. Media were constantly trying to get involved, constantly trying to get to me through various people, various means. I'll never forget one call from this idiot. He got my cell phone number. I don't know how. And he was very, very straightforward. He said, if you'll give me some hot documents, I'll tell you who in the prosecuting office is sleeping with the media. Okay? I said, I don't care who they're sleeping with. You're not getting any documents from me. There's a gag order, and I hung up. But there were constant efforts to try and find a way to profit off this case. Linda Deutsch, who I have great respect for, who was really the dean of trial reporters with Associated Press, who began with the Manson case, and she's followed virtually every major case since then, told me it was a dreadful experience. She hated the Jackson trial. She lived in a nearby hotel. She said she never saw so many people gloating, over the fact that they were going to profit off this case. And it just really disturbed her, the extraordinary tabloidization of everything that happened in the case. But at any rate, by supporting the gag order, I could tell Michael and his family, I can't address that issue. We've got to win this case in the courtroom. We're not allowed to. It was a great relief to me to be able to follow that course because, as I said before, you win these cases with juries, You don't win them in the media, in my opinion. You want to be concerned with the media. You want to get some good information out if you can. You want to level the table if you can, but don't get too carried away with it. You'll lose focus. You'll start to think it's all about you. It's not about you. It's about your client. And I think we handle that very well. Now, Susan Yu, my co-counsel and law partner, had her own condo not far from the courthouse, good distance from the hotels. I had my condo. Our staff had their condos. We had one duplex we call the War Room, and basically we were like an armed camp. I mean, you know, we were not near the media, not near the hotels. My schedule was getting to bed at 3 in the morning, getting to bed at 7:30, 8 o'clock, getting up at 3 in the morning. I never was seen in a restaurant, never seen in a bar. Nobody could take a photograph and try and put me in a compromising position. I wouldn't do that. Susan goes to bed real early, gets up at 3. Our staff were sometimes up all night updating witness books, and that's how we lived. We lived a very, very disciplined, very sheltered, very focused kind of existence during this trial that was almost 5 months. As far as the case goes, I have to tell you, I've never seen so many witnesses provide so much salacious, disturbing testimony, and I've never seen so many witnesses crumble so quickly under cross-examination. I'll probably never see it again. I mean, it almost became a circus. People would get on that stand and say they'd seen the most horrific things on the planet. There would be just a heavy atmosphere in the courtroom. So you could almost cut the silence with a knife after they were finished. And on cross-examination, they would just splatter. Now, let me give you an example, just a general example of what I'm talking about. The prosecution introduced evidence that 5 young men had been molested separate and apart from the accuser in the case. And all the pundits were saying, you know, this law in California is so harsh, so draconian, you can't survive it. You know, once that evidence of other similar acts comes in, you're dead, no matter what happened. Well, we started our case with 3 of those 5 young men who they claim were molested, and they all said, he never touched me. That's how we began our case, 3 of the 5. The 4th one never showed up. And if he had, I think we were armed pretty well to deal with him, and that's Larry Feldman's client. There are a lot of other issues that go into that case that I don't have time to talk about. But let's just say that I had a lot of information to go after him on, not to mention the profit motive. Why do you take money and not go to the police and prosecute? Particularly, you know, if you're a family member, do you prefer to take money instead of having police and prosecutors go after you criminally? What does that tell you about the situation? The 5th young man was a so-called youth pastor who claimed he'd been tickled by Michael Jackson outside of his genes and needed 5 years' worth of therapy to deal with his trauma. And by the way, he wanted millions of dollars, his mother wanted it, and his mother also sold story to the tabloids. So they're the 5 people that the prosecution claimed had been molested by Michael, separate and apart from this accuser. Okay? Now, by the way, again, you know, Ron feels very strongly about this. I do too. I do too. The man was innocent. Now, the accuser in this case, who Ron feels so highly about, and that's absolutely his privilege, in my opinion, I think we proved this, had assisted his mother in a false sexual harassment claim against JCPenney stores. He was a child who took a sworn deposition to support her claim that she'd been sexually attacked in a parking lot by security guards, and we proved it was completely, utterly bogus. We got the intake information at the police department. She didn't have a bruise on her body, a hair out of place, that she didn't need medical attention. She pops up a few weeks later with photographs showing all this bruising. And we had a paralegal from the law firm that represented her in the case who kept calling me in tears. She was just devastated about what to do. She said, this woman told me it never happened, and I'm afraid to lose my job. We had one of the lawyers from the firm testify. The privilege ended up waived. And he said that he had talked to this woman about these events. She said she was assaulted, never said sexually assaulted till her deposition. He said it was the first time she'd ever come up with that story. He was shocked. I mean, I've got to tell you, there's another side to this, or a very conservative jury in Santa Maria, California, wouldn't have exonerated Michael Jackson so thoroughly and so completely. Look, this young man, you know, is entitled to say what he wants, and he may be doing very well. But I think he got caught in so many lies, so many misstatements. We had a video where he and his family all said it never happened. We had an investigator's statement, audio recorded, where they all said it never happened. And suddenly the alleged dates of the molestation changed beyond the video. Initially, the prosecutors were claiming the molestation started on a particular date, and when this evidence was discovered, they moved the date beyond that evidence. I mean, it was like, let's just adjust to what we have and make sure we go forward with the case, in my particular opinion. Okay? I know we're going to talk about jury selection, but I just have to tell you that this was a quick jury selection. Most people think in high-profile cases you're going to be there months investigating everybody's background. This was, I think, a day and a half, wasn't it, Judge?
After hardship.
Yeah, after hardships, a day and a half. I gave up half my peremptories and just took the panel, which seemed to shock some people. I mean, the goal is not to use your peremptories. The goal is to get the best panel you think you can get. That's what you're there to do. And we had a feeling that we had a panel that would be particularly fair. Now, there were some controversial decisions that were made in that process. I guess we're talking about jury selection later? Okay. But I just want to tell
We're talking about jury selection.
Okay. The trial was agonizing. There may have been about 140 or so witnesses testified in the trial. Judge Melville was a workhorse. We were in there 5 days a week. There were hardly any dark days during the trial. I did like that schedule with small breaks rather than a major lunch break. I thought it did fit well into our ability to go back and prepare for the next day. But it was backbreaking. It was agonizing. The media, just the way they reported the case was just remarkable. They would hear salacious testimony, and the reporters would run out and report it. They would not wait for the cross most of the time, or they'd want to ignore the cross. And it was just clearly their goal was ratings, revenue, which you would expect. They're nothing but businesses. And their goal was to see him go down. As far as client control, client efforts, I mean, this was the nicest client Susan and I have ever dealt with. I'll tell you that. He was extremely down to earth, very cooperative, very nice, never tried to get in our way. The problem was people around him. Poor Michael Jackson has always attracted just a large number of just very disingenuous types who would try to ingratiate themselves with him, try to make him think they were his friend, and then turn on him in some way. They were always nipping at our heels, lawyers always trying to get to him, always trying to criticize what we were doing. That was sometimes I felt I was more at war with my own camp than anyone else, because you just never knew who was going to get to Neverland through who to try and convince him that things were going wrong and they're needed. What happens with celebrities so often is this, people want to be around them, and they try to create a need for themselves. What they try to do is keep the celebrity off balance, insecure, terrified, scared. They create their need, and they don't want that need to be fulfilled or they won't be needed anymore. So basically they're constantly trying to get their 2 cents in to keep the celebrity off balance, scared, and create a reason why they should be there. And Michael was probably the biggest target of that I've ever seen. The first prosecution witness was Mr. Bashir. I thought he was a disaster for the prosecution. He was asserting the journalistic privilege. He wouldn't answer just basic questions that couldn't possibly hurt him in any shape or form if he was willing to answer them, and he just wouldn't. And basically what I did was I decided, as I think most good cross-examiners do, to tell my story through my questions. And I kept asking him long-winded questions about, isn't it true, Michael Jackson told you he never touched any child sexually, never would do that, blah, blah, blah. And he would assert the privilege. And then I would ask my next question, and I would tell my story, and I would recite my facts. Isn't it true? When you confronted Michael Jackson with A, B, C, D, and E, he told you he would never, ever do anything like that. And isn't it true that you told him he was a wonderful parent, et cetera, and on and on and on. A lot of people around the country that I talked to were surprised that the prosecution was able to play his documentary. But I have to say, fortunately, Michael Jackson was smart enough to have his own videographer at those interviews, and there were outtakes that Bashir kept out of his documentary, which we were allowed to play by Judge Melville, because basically the prosecutors got their shot at a very selectively edited bunch of hearsay, and we got our edited out outtakes as a result, and he denied every single allegation, said I'd even slit my wrists before I'd hurt a child. I think a lot of the things the prosecution tried to do, we were able to neutralize by basically putting it into a different perspective. The prosecutors, and I've heard tonight, he sleeps with boys, sleeps with boys, sleeps with boys. Well, we showed he sleeps with mothers, he sleeps with sisters, he sleeps with all kinds of people because they wanted to sack out in his room, which was about as big as his building. I mean, there was a different, the prosecution were out to get him in the best way they could. I understand that. But I think the person they chose as the victim, as the accuser, and particularly that person's family, were really a disaster for them. They brought a conspiracy charge that Michael Jackson had masterminded a criminal conspiracy to abduct children, commit extortion, and falsely imprison a family. Michael Jackson couldn't even imagine such behavior, let alone orchestrate it. And what that charge did for them, and I can't get in the minds of the prosecutors, but here's what I think they were doing. That allowed the mother, who was really the linchpin of a lot of their case, to bring in co-conspirator hearsay under the exception. It allowed them to intimidate witnesses who were at Neverland because they were fearful they would be indicted as conspirators. Great conspiracy here. The only person they charged was Michael Jackson. Everyone else is unindicted. She brings the hearsay testimony in. The witnesses who can refute it are terrified to come to court for fear they'll be indicted, so they lawyer up. And plus, it makes Michael Jackson look like this mafioso-type guru, which he's not even capable of being. Not even capable of being. But at any rate, the trial went forward. There were just tons of surprises. I mean, I think Judge Melville will agree this probably had more crazy things in the courtroom than he ever expected, correct? I mean, it just, much of the time I made my cross-examinations lengthy. Some of them were days. I think there was one was about 4 days total. I just decided that there were so many facts in our favor to neutralize these witnesses, particularly these accusers, that I just felt there was no way these people were going to last, no way they were going to just withstand the facts. And I don't think they did. I don't think they did at all. We had a very, very responsible jury that was out for about 7, 8 days. It was a right verdict. I look forward to the questions. Thank you.
Well, that may give you some impression of what an effective defense counsel can do in arguing to a jury. We will be approaching our end result. Were we to quit at 9 or 9:15? Who's the authority? 9:30. I should have been in bed a long time ago with this. All right. Let's turn to the jury selection point. A number of people have mentioned it, and they very kindly passed it by as they did, so that we can treat it all at once. I think it is a very important issue and something that as lawyers we can learn something about the attitudes involved. Judge Melville, would you like to say something further about that issue first?
Jury selection?
Yes.
Yes. I thought it was 9:15, but who am I? This is just some preliminary on the jury selection, and I say this, that the management of the jurors proved to be one of the more challenging tasks. Initially, a large hall was used to meet with the jurors for admonitions and instructions. Then we brought them back in groups and took excuses from those who could not serve the length of the estimated time for trial, which I recall was 6 months estimate. After the hardship excuses were heard, deferments granted, and jury questionnaires filled out, we ended up, surprising to me, with a lot of people who wanted to serve on this jury. As a result, jury selection went very quickly. We selected 12 jurors and 8 alternates. Our jury box only had 14 chairs. In anticipation of this and to save money, Darrell went on eBay and found theater seating available for $46 a seat. We had a, quote, that up to that point of $10,000 for new jury chairs. So including shipping, we paid $46 a chair for 20 chairs. As the trial progressed, each morning we had the jurors meet in an adjoining building some distance from the courtroom. They would come over in groups escorted by several bailiffs, and the day would begin. As the trial progressed, time passed, there were bumps with the jurors. But I felt nothing was serious enough to divert the energies of the court away from the progress of the case. Of course, there was an order that prevented the pictures being taken of the jurors, and their names were not revealed by the court. One day, a sheriff's deputy caught a photographer taking pictures of the jurors as they arrived at court. The camera was seized, the images were removed, and the photographer was banned from the court campus permanently. During deliberations, jurors complained of suspicious cars following them and flowers being delivered to their homes with invitations to be on television talk shows. Upon the completion of the trial, we provided a space at the courthouse for those jurors who were willing to talk to the media. It was our thought that they needed a safe place for their discussion if they cared to share those thoughts. They talked for over an hour. We also set up a safe place for them to talk to the TV program bookers if they desired. Again, I thought a little supervision at this juncture would go a long way. I'll turn it over to
Thank you. Ron, from your point of view, and let's deal now with the lawyer's question, Tom and Ron. What were you looking for in a juror? How did you go about trying to find it? I know, voir dire, but that sort of thing. And how was your conduct in the courtroom affected by that juror? Did you do anything in the courtroom because of your anticipation of what the jurors might think? That sort of thing.
Well, you know, it is on. All right, you can hear me. I thought that I handled jury selection to a large extent the way I've been handling jury selection for the 25 preceding years that I've been trying cases. And I didn't do anything too terribly different. Of course, we did have questionnaires from each of the jurors that we had an opportunity to review. We had a jury selection expert. They had a jury selection expert. I doubt that I would do that again in the future. I don't think that I found it particularly helpful. What caused me a lot of concern at the very beginning, I went to that first day for challenges, the ones who couldn't be, and I watched the juries parade into the courtroom. And again, we were always concerned about the issue of celebrity. When you have somebody who's recognized as quite possibly the single most famous person in the world, certainly at the time that at the peak of his career he was that way, and clearly the most recognizable person in the history of modern times in show business. That's what we were dealing with. We were concerned how we would respond to that. And I watched the jurors coming in as they were walking in the door. They would stop about 6 feet in when they would see Michael Jackson and just come to a complete halt and just look at him. There was nothing else that was going on in the courtroom at the time. And this entire panel was brought in. We went through the hardship challenges. It was expected it was going to be about a 6-month trial. And we, for the most part, Judge Melville, for the most part, excused anybody who got up there and said it is an undue hardship, a financial hardship. Well, immediately we lost anybody who had a business, anybody who ran a business, anybody who had an important position where they couldn't be away from their job for a period of 6 months. We lost all of the people who I like to put on juries generally, and who we were left with were people who were unemployed, underemployed, or retired to a large extent, or students. And that's the body of people who certainly should be represented on juries, but not necessarily as the majority or the entirety of the jury. So that was the big issue that we were dealing with. And once we started jury selection, we dealt with a great deal of what I thought to be inappropriate levity on the part of some of the jurors once they were in front of an audience filled with celebrities, many of whom on the jury knew many of whom in the audience. People like Greta Van Susteren or Dan Abrams or many people who use, if you watch television news in the morning and the afternoon, you saw a lot of faces that you recognize. And it became difficult to deal with a lot of the people who were there who did not want to take that moment terribly seriously. And it became difficult for us. For me personally, it wasn't the kind of jury that I was used to selecting in Santa Barbara. Wasn't the same level of education, wasn't the same level of professional accomplishment. and that ended up being a problem. During the course of the trial, afterward, we were able to determine that a few of the jurors had continued to read the newspaper in violation of the court's directives. During much of the trial, at least one of the jurors was negotiating a book deal during the trial. Had the verdict come back guilty, I suspect it would not have stood. It would have been reversed because of some of those actions. All of the jurors that day or the next day immediately got on a Learjet and flew to New York, where they participated in a number of different television shows and had an agent essentially representing in total. It was a difficult experience. As you can imagine, I never felt it was a jury that was the type of jury that I would have liked to have selected. Obviously, my fears were borne out. They did deliberate for 8 days. I'm not sure what they discussed for 8 days afterward, based on statements that they had made. But that's ultimately how the case was resolved, and those were the issues that we dealt with in jury selection. Huh?
We had a jury consultant, and quite honestly, Susan, you and I talked a lot about her suggestions and rejected all of them. For example, she thought that women were going to be bad for us, particularly mothers. It's a molestation case. We decided women were our number one desire. We weren't worried about this molestation sort of affect closing people's minds. We felt Michael is a very eccentric artist. He appears different. He looks different. He's a creative spirit. We wanted people that were open to that. I've always felt that women, generally speaking, are much more open to that kind of behavior, that kind of aura, that kind of style about your life than many men who can be harshly judgmental very quickly. We wanted people that we thought were independent-minded. It was an intelligent jury. We had a civil engineer. We had a math teacher with a master's in math. We had a retired school principal with a master's in counseling. We had people with military experience. We had one woman that ran a local social services agency. It was a very intelligent jury. And I must say I disagree with Ron. Had it been a guilty verdict, they still would have been on a plane to New York to go to Good Morning America, or they just would have, in my opinion. It was a jury that I just had a feeling would be very open-minded. And I wanted people who were independent. I was under attack quite a bit for not seeking a change of venue by people in the Michael Jackson camp. And I had hung out in some bars and restaurants early and really discovered that Michael was not disliked in this community. A lot of people had a very decent impression of him. The allegations are horrific, let's face it. They're about the worst you can have. But I felt it was a very independent-minded community. I learned, as I said before, having never tried a case up there, I learned that northern Santa Barbara County is somewhat different from south Santa Barbara County, that while the city of Santa Barbara is thought to be more liberal than, say, the city of Santa Maria, that people are supposed to be more conservative in that venue, they're also probably a lot more libertarian, meaning government, we respect you, we're good people, don't go too far in intruding in what we do. I had a feeling Michael was their celebrity in that county. He was not hated at all, and I didn't want to change a venue. Not only that, under the rules, I could have asked for some jurors to be shipped up from the city of Santa Barbara in the south, and I didn't do that because I felt that local jurors would think that was a vote of non-confidence. I was attacked for doing that as well by some people in our camp. Had great faith in the community, liked the community, thought it was filled with very decent, honorable people, strong-willed people, thought the jury would be fair, and I really think they were.
Do any other members of the panel have anything they'd like to offer on jury selection in an important case where you have such a high-profile party?
Well, Seth, I'm amazed that they were able to select this jury in a day and a half. I can remember how we spent 6 weeks in the Simpson case picking a jury with many of the same issues. And I'd also like to echo the counterintuitive belief that the jurors in Santa Maria would be disfavorably disposed towards Michael Jackson. I know I represented him on and off for many years, and he had not just this criminal trial, but one and I think two other civil trials in the area, and he won both of those as well. There was a trial I can recall where several security guards alleged wrongdoing in an employment context, that he won that case. And I think there's one other as well, Judge Mabel. So he had always contributed to that community. He was well known, and he was, in fact, beloved. And oftentimes, these kinds of cases takes a very strong, self-confident lawyer to do well, because you are always the subject of slings and arrows by many who may not have your temerity or have your confidence. And it's really a testament to Tom and to Susan what they were able to do, because I can appreciate some of the slings and arrows that were headed their way. I heard some of them myself on the QT, and that they were able to generate this result is a testament to their ability as lawyers.
Any other comments from the panel on jury selection? Difficult problem. I have one question here that isn't quite jury selection, but it's jury evaluation, I guess. And so let me read this question and see which one of you would like to take a shot at it. It's addressed apparently to the judge and the lawyers, so I guess anybody has a fair shot. Do you think that there might have been a different result if the trial had occurred in a different venue, such as Los Angeles? Well, Tom can't very well say that he's interested in that after his speech, but who would like to respond to that?
I don't think it was so much the venue, if you're talking about the second case. I think it was more, I think Tom alluded to it, I think it's a totally different lawsuit if you could keep the mother out of the case. The mother, in both cases, the parents are complicit in these things. And the natural instinct of people in these kinds of cases is to, how could the parents let something like this happen? When you bring these cases of false imprisonment, and Jackson's got he's kidnapping him, and then they're going back to Neverland, and you just keep broadening the case, you are playing right into the defendant's game. If you file one count of sexual molestation, and that's what occurred, if it occurred, I don't know what happened, but if it occurred, then you have a much better chance to get a conviction. There's less to fight about. And I think those are significant things, and it's no different than in a rape case. If it's any sexual molestation case, whether it's rape or it's Michael Jackson or it is highly emotional, there is a lot that's going on in victims and about their willingness to testify. I mean, I heard Tom say, for example, that he was all ready to go after the boy because he took $20 million and he didn't go through a criminal trial. I mean, so I understand him going to go after him as a defense lawyer. If I was where he was, I would have done the same thing. That's what you're going to do. But the truth is, there's God is watching. The truth is that these are real victims. These are real people. I don't know what happened, and I'm not saying what happened because I wasn't there, but these are real people. There are real women who have to decide whether they're going to let a good lawyer like Tom cross-examine them when they say his client raped somebody. This boy who didn't come back, who was outside the jurisdiction, had real issues to decide. He was living anonymously. He never, from age 13 to 30, never, ever was involved with the press, never gave an interview with the press, went to college, was living a secret, private life. And was he going to come back to Santa Maria and let you, argue with him about why he didn't go to the police at this stage in his life. You may think you have all this evidence, but that's real moral issues these people have to decide for themselves. It's easy for me to say you ought to do it, stand up, you owe it to all the other people, but in reality, it's their lives, and there's a lot at stake. And we as lawyers sometimes, we know all the moves to cross-examine someone, and we all do it, and that's our job. But there are a lot of people's lives that hold in the balance, and I don't think in any charged sexual molestation case, which is now in the media, just compounds all the problems that everybody faces in ones that don't get in the press.
Seth, I think that there probably would have been a difference had the matter been tried in Los Angeles, because I think he would have been afforded the opportunity to have a more diverse jury than he would have had in Santa Barbara. I'm the only African-American lawyer that is up on this panel, and I've been practicing law both in criminal and civil courts in Los Angeles for the last 30 years. And I factor in race in everything that I do as a lawyer in Los Angeles. Like it or not, it is a reality that I have to face to my peril if I ignore it. And I suggest that if there had been a trial in Los Angeles with a 6-month estimate and the need to first pre-qualify a jury panel for hardships, I would gather that there would likely have been more prospective jurors that looked more like Mr. Jackson than there probably were in Santa Maria. And by that token, there would probably have been a healthier cynicism to some of the police-based attacks, and there probably would have been a greater resonance, if that's possible, to some of Tom's cross-examinations that drew questions into some of the motives of many of the prosecution witnesses. Rightly or wrongly, African-American communities loved Michael Jackson and rejected the allegations both in '93 and in 2005. And while I think that the verdict was more a consequence of great lawyering, there would have been a jury pool more receptive to some of the broader-based attacks on the police and on the prosecution than I gathered there was in Santa Maria.
Anyone else want to discuss that subject? Let's have a little switch here for the moment, a complete change. Question that maybe it's not a Fifth Amendment privilege to be cited here, but a question that probably won't get answered. It's a question to Tom. Are you planning to write a book about the Jackson trial?
Not at the moment.
That's pretty much a non-committal answer? All right, here's another question, really off the beat, and one that frankly can't be answered very well, I don't think. But in any event, I suspect probably the first guy to have to answer it, well, Larry or Carl. Let's have Carl take a first shot at it because it has some complications. In a large profile case, how do you ascertain what is a reasonable fee to charge?
As much as you can get. Right.
Well, yes, that's the first point. Now, what's the second point?
You take it from there.
I'm always mindful of the advice of a great lawyer who died this year by the name of Charles Lloyd. And Charlie always said that you ask twice of what you want and ask for half up front. And that's always a good technique. In our experience, it is always a very important issue that lawyers have to consider. I know in Michael Jackson's case, we were in many ways confronted with some of the economic realities that he was faced at that time, because although Michael continued to live like it was 1984, his purse strings did not resemble that lifestyle that he was continuing to live. So it's always a challenge. Whenever you get a high-profile case as a criminal lawyer, all you're looking at are dollar signs, and you're trying to figure out how much you can ask for, which is not 100%, but maybe 85%, so that you can persuade the client to retain you and still maximize what you can do in terms of your own personal perspective and business judgment. But it's difficult. I remember, for example, in the O.J. Simpson experience, that the firm probably generated 40% of revenue during the 16 months that we were working on the case than we had the year before when we were not on the case. Now, I'm sure Johnny made a cost-benefit analysis and thought that with the added profile that it would work out in the end, and ultimately for him it proved very reasonable, but it's not always as beneficial financially as one would think up front. Oftentimes, and Tom can, or others can confirm, celebrity folks are often kind of cheap with their money, particularly as it comes to paying for lawyers. They don't have often the same willingness to share as you would think or as their profile might otherwise suggest.
Well, I certainly wouldn't suggest that the last two questions haven't been answered, but I'm going to pass on to a third question. Unless, Larry, you wanted to speak to that.
No.
All right. This is one I would have expected earlier, and it finally came in. For Judge Millville and the lawyers, please tell us about the pajama incident. Anybody want to tackle that one?
I can do that. Michael called me one morning, and he had been walking through Neverland in the dark. He fell. He had injured his back. He was at the hospital. And I promptly reported that to Judge Melville, who didn't like what he was hearing, and ordered him in. I think it was 45 minutes, or was it 30 minutes? 60. 60? Oh, okay. 60 minutes. I told Michael and his people in no uncertain terms he's not to go home and change. He's to get to court right away. I don't want him remanded to jail. I don't want his bail yanked. That will be a disaster. And he listened to what I told him to do. And he had pajama bottoms. He had a jacket on and a shirt. And the press just went crazy. I have to tell you, after the trial, I talked to a couple of jurors, including the foreperson, who told me that they didn't even notice it. When they came into the courtroom, he was seated at a counsel table surrounded by his attorneys. And they never even noticed it, and they said it never meant a thing to them. But the press went berserk.
I thought it was one of his more conservative looks, actually.
Any rate, I think the press just made a mountain out of a molehill. And I don't think it had any effect on the trial whatsoever. But Michael was such a target. You know, they would just try and find any little detail and try and make a huge, production out of it. And unfortunately, that happened throughout his life, and I think it was one of the sadder aspects of his life.
Here's a difficult question. And probably Tom is the guy to give us at least a first answer to it. Isn't Jackson 2, the trial, really all about the continuing vitality of reasonable doubt, given that many of the jurors said after the trial that they believed Jackson was guilty, but that it just hadn't been proved beyond a reasonable doubt? Didn't the problems with the mother alone create reasonable doubt regardless of Jackson's guilt?
Well, first of all, my understanding was that one juror said that. That was the civil engineer, said that he felt there was definitely reasonable doubt, and that's why he voted for acquittal. I don't recall any other juror saying that I just did this on the basis of reasonable doubt. Maybe they did. I don't recall that. I know some of the jurors I talked to were just appalled at the charges and appalled at the quality of the witnesses and the testimony. I do think this verdict was a great victory for the justice system. It showed that jurors take their job very seriously, that they're impervious to media onslaughts, that they try to do what's right. They try to look at the evidence in the courtroom, and I think it was a great testament to the validity and the integrity and fairness of our jury system.
Here's a question, a procedural question, really, Larry and Carl. How did a three-judge settlement panel get established? Because that's unusual in the Superior Court. My guess is you're remediating, but you tell me.
Well, we had to have a safe place because we were, I forget what our trial date was.
March 24th.
So it was March 24th. And Johnny got in the case, in, as Carl said, I guess December, and this all happened in January. So, and there had never been a discussion about resolving the case on either side up until then. And I think we wanted, as Carl said, Johnny had been doing a lot of plaintiff's work, and so we wanted judges that we could trust. And both sides had a lot of convincing to do of their respective clients about settling and the value of the case and what's in the best interest of the young boy, and from their perspective, what was in the interest of Michael Jackson. And that wasn't simple. And we thought if we could get more than one judge, three respected judges, respected, that we had a much better chance to get the case resolved. So we picked three judges, all retired, all with well-liked by at least Johnny and I speak for Carl. We had a lot of respect for him. We had appeared before him many, many times. We tried cases before these judges. I mean, we really knew them, and we trusted them. And that's how that occurred. And
So that was just a voluntary agreement.
just a total voluntary agreement. To put it into some context, at the point this case settled, a lot of witnesses had been deposed, but Michael Jackson had not been deposed. And at some point in time, Michael Jackson was going to have to decide whether he was going to take the Fifth Amendment, which he didn't at that point, or whether he was going to let us depose him. And there was a lot of procedural maneuvering by the defense to try to keep putting that decision off. And as that decision and their moves were not able to accomplish what they wanted, which was never to have Michael Jackson take the Fifth Amendment. And, you know, if Michael Jackson takes the Fifth Amendment in a civil case, that is bad for that civil case. And that's probably bad for him ultimately winning. And we can all say that the Constitution, you have a right to do it, and blah, blah, blah. We'd all say you do. But the practical effect of that in front of a jury would be devastating in the public at that time for his career. So we had narrowed the moves that he could make to try to keep putting off this deposition. We sent him interrogatories. They didn't answer them. We noticed his depo. He didn't show. I mean, so, you know, and we were playing against, we're down to the last 60 days, basically. So I think that was the stage of this thing. The one thing you get in these cases, I'm sure it's for both sides, you get a lot of people that want to testify, that come up with these stories that you know, when the phone rings and you hear the story, you think you got a great witness. And then as you spend the money and the time and the energy to chase down the story to see if there's any accuracy, you find out that these people are not truthful. They just want to get involved in the case. And so it's the job of both sides, and it winds up on the plaintiff's side costing an awful lot of money that in contingent cases you're generally advancing to find out really who are the real witnesses that aren't going to get destroyed. And which of those witnesses really hold up on cross-examination? Which of those witnesses have corroboration? And In Jackson 1, when there finally was somebody that we cracked, the first thing they did is they ran to the media, ran to the television and got paid to give their story on television before we got them on a deposition under oath. They ultimately testified under oath, but, I mean, those kinds of issues where somebody's getting paid just are devastating, and you put it in the hands of Johnny or Tom or Carl, and you give them a witness who's gotten paid to give their testimony, even if they're telling the truth. By the time they get done with them, they're not, jury's going to have doubt about that witness. And so in these high publicity cases, you are confronted with that. And the other point I'd just like to make is this, that we haven't talked about. It's the next case that you could also worry about. When you're on television, I mean, a guy like Tom, I guess you would notice him with his hair and stuff. The next case, if he has a juror who thought Michael Jackson was guilty and that he did something wrong in defending him, that could work against the next client. In the civil arena, we found just the opposite of what Michael. In the next cases I tried, and we would be screening jurors, we found that it helped the jurors. It helped me in every case thereafter. The jurors recognized me from that case at that time. So it's very important that when you do this, you do it right. You cannot make a fool out of yourself. You cannot be one of these people that are on television all the time just spouting out. You have to do it with a bit of class and hopefully a little professionalism so that no matter how it comes out, you come out okay for the next case and the next client.
And if I adopt everything that Larry said, and in our perspective, you got to remember that there was a companion criminal case or investigation going on by both the district attorney's office in Los Angeles and in Santa Barbara. There had been an occasion when Michael Jackson was examined and his genitalia was recorded, which was part of an investigation, and that was the 300-pound gorilla in the mediation room. We wanted to do all that we could to avoid the possibility that there would be a criminal criminal filing against Michael Jackson. And the reality was we were hopeful that if we were able to, quote-unquote, silence the accuser, that would obviate the need for any concern about the criminal side. So from our perspective, there was a great deal of trust, not only with Johnny and Larry because they had a 20-year prior friendship. There was tremendous trust with Johnny and the three judges being recommended, and we were facing the purple gorilla in the room of, if we don't get this case settled before March, there is a criminal investigation looming, and no one wanted to consider the implications of that as it affected Michael Jackson, the king of pop.
Thank you. Thank you. You have almost earned your 3 hours and 15 minutes of credit, but I have one more question to which I will only accept one answer, and I'm not sure we will get one. But having heard what we have, the question that I indicated that we should look at sometime is, what do you think was the most interesting, unusual, surprising, spectacular event in the trial? There wasn't any. It certainly wasn't the pajama incident.
For me, the most spectacular event was verdict day.
That's always a
the energy, the just moment-to-moment wait for Michael and his friends and family to arrive at the courthouse. I'll never forget that day. It's very difficult to describe. Woke up that morning and just had a feeling something wild was going to happen, and I wasn't wrong. It just was every second seemed like 10 hours. It was quite a day.
Well, it is a spectacular time, any jury trial, when you wait for that phone to ring that the jury's coming in and you're going down to listen. Well, you've all been very attentive. We appreciate that. I think you have completely earned your 3.5 hours, and I will sign up you for more. Thank you very much.